Before most Americans even opened their eyes, something fundamental changed. No press conference, no televised debate, no warning banners scrolling across the screen. In the quiet hours of the morning, the Supreme Court quietly rewired how power actually works in the United States. A 6-3 emergency ruling slipped into place, and with it, the ground beneath American rights shifted overnight. This wasn't a procedural adjustment or a narrow legal fix. It was a structural move that redefines how protection, authority, and resistance operate, whether people realize it yet or not. What makes this moment unsettling isn't just the decision itself, but how it happened. No oral arguments, no months of public scrutiny, no slow deliberation. Through an emergency procedure rarely understood by the public, the court issued a ruling that takes effect almost immediately. These are the kinds of decisions that don't feel real until they collide with everyday life. And by the time that happens, the legal terrain has already changed beyond recognition. This ruling does not simply touch one policy or resolve a single dispute. It alters the mechanism through which constitutional challenges function in America. For decades, federal courts had the power to freeze laws nationwide while cases worked their way through the system. That safeguard has now been effectively dismantled. One judge can no longer press pause on a federal policy for the entire country. That era has ended. Quietly, abruptly, and decisively. The case itself revolved around a high-stakes executive order tied to birthright citizenship. But the court used this dispute as a vehicle for something much larger. Beneath the surface, a long-running internal battle over judicial power finally broke into the open. What looks like a technical legal ruling is actually the culmination of decades of ideological conflict about who gets to stop the government, and when. This wasn't just another Supreme Court headline. It was a tectonic realignment between judges, presidents, and the public. From Washington, D.C. to California, the rules of the game were rewritten in a matter of hours. And most people are still walking around unaware that the system protecting their rights no longer works the way it did yesterday. At the center of this ruling is a concept most Americans have never heard of, yet have depended on for years: nationwide injunctions. These orders allowed a single federal judge to temporarily block a law or policy from being enforced anywhere in the country. Immigration rules, healthcare mandates, environmental regulations, labor standards, voting procedures, all of them were shaped by this judicial tool. One courtroom decision could stop a federal action nationwide. That power no longer exists. Under the new framework, judges may only protect the specific plaintiffs before them. Even if a policy is deemed unconstitutional, it can still be enforced against everyone else. That means a law can be blocked in one district while fully operational in another. Rights that once applied uniformly now fracture along geographic lines. Where you live suddenly matters more than what the Constitution says on paper. For the past 25 years, nationwide injunctions acted as an emergency brake. They prevented irreversible harm while courts sorted out complex constitutional questions. Without them, the legal system shifts from prevention to reaction. People must now suffer the consequences of a law before challenging it, and only if they have the resources to do so. According to court filings, there are currently dozens of active nationwide injunctions affecting everything from workplace safety to access to prescription drugs and election administration. Many of these protections could collapse within the next 60 to 90 days as lower courts scramble to reinterpret their authority. The timing could not be more volatile. America is heading straight into an election cycle already defined by conflict: immigration, healthcare, civil rights, voting access. This decision doesn't just influence those battles, it changes how they will be fought. The battlefield itself has been redrawn. The majority opinion, written by Justice Amy Coney Barrett and joined by Chief Justice Roberts, along with Justices Alito, Gorsuch, Kavanaugh, and Thomas, rests on a deceptively simple claim. According to them, the Judiciary Act of 1789 never granted judges the authority to protect people who are not directly involved in a lawsuit. Courts, they argue, exist to resolve specific disputes between specific parties, not to function as a national veto on presidential or congressional action. But the most explosive reasoning came not from the main opinion, but from Justice Gorsuch's concurrence. He traced judicial practice back to the 19th century and argued that American courts historically refused to extend relief beyond the actual plaintiffs standing before them. In his view, nationwide injunctions are not a constitutional tradition. They are a modern invention. Justice Thomas went even further. He argued that national injunctions encouraged strategic judge shopping, where advocacy groups seek out sympathetic courts to shut down policies they oppose. From this perspective, the court wasn't limiting power, it was reclaiming it. And with that, the majority declared this era officially over. The dissent saw something entirely different. Led by Justice Sotomayor, they warned that stripping courts of universal relief hands enormous power to the executive branch. Under this system, unconstitutional policies can remain in force for years, while individual lawsuits crawl through the courts. Their warning was blunt. Constitutional rights risk becoming privileges reserved for those who can afford prolonged legal battles. Justice, under this framework, becomes uneven, delayed, and deeply unequal. This isn't theoretical. Within 48 hours of the ruling, the legal landscape began shifting in real time. Attorneys general from 18 states filed emergency motions, either attempting to preserve existing injunctions or to immediately enforce laws that had been frozen for years. Texas moved aggressively to revive immigration enforcement blocked under the old system. Florida launched emergency actions targeting social media regulation and election procedures. California and New York responded with their own filings, desperately trying to maintain nationwide blocks on federal policies they oppose. Behind the scenes, the Department of Justice convened emergency strategy sessions involving hundreds of federal attorneys across dozens of active cases. The White House Counsel's office quietly warned federal agencies to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. The speed and scale of the response tell you everything you need to know. Legal strategists see this as a massive shift toward executive power and a devastating blow to judicial resistance. Advocacy organizations across the political spectrum are scrambling. Groups that once relied on nationwide injunctions as their most powerful legal weapon now find that tool gone. Major law firms are warning clients that constitutional litigation could now cost 5 to 8 times more, requiring lawsuits across multiple jurisdictions instead of one decisive case. This is where the decision becomes deeply personal. Immigration enforcement is the first pressure point. There are currently multiple injunctions limiting federal immigration practices nationwide. Under the new system, those protections may apply only to specific plaintiffs in specific districts. Enforcement could look radically different depending on where you live. The same applies to gun rights, healthcare access, environmental protections, workplace regulations, and election laws. Your rights now depend on geography. America risks entering an era where federal law exists on paper, but is enforced unevenly across the country. One constitution, 50 interpretations, dozens of realities. As the 2026 election cycle approaches, election officials are already warning of a nightmare scenario. Voting rules varying not by state law, but by court boundaries. Corporate America is also alarmed. Companies operating across multiple states may now face conflicting federal regulations depending on location. Banks, healthcare providers, technology firms, and pharmaceutical companies are warning of massive compliance costs and regulatory chaos. Estimates suggest this legal fragmentation could cost businesses tens of billions of dollars annually. This ruling is not an isolated act. It is part of a broader Supreme Court strategy that increasingly relies on emergency procedures to reshape law without full briefing or explanation. Critics warn this creates a chilling effect, where lower courts hesitate to block even clearly unconstitutional actions out of fear of swift reversal. The court has not merely changed a legal rule, it has changed what protection means in America. Whether this represents a return to constitutional originalism or a dangerous fragmentation of the rule of law depends on perspective. But one fact is undeniable. The legal patchwork era has arrived, and its consequences will shape immigration, elections, civil rights, and economic stability for years to come.